You may call your next witness.
Your Honor, the state's going to rest at this time.
Okay, state rests. And so now it's your opportunity to put on your own case. Did you wish to put on a case? If so, will you be making an opening statement?
Your Honor, I believe that earlier you said we can't make verbal motions in front of the jury, right?
Okay.
I would like to
and
make
so you wanted to make a motion?
Yes, ma'am.
Okay. And so we'll go ahead and excuse the jury so that a motion can be made.
All right, please.
And be seated. What is your motion?
I actually have the whole letters and numbers to it. It's ICR, whoa, what's that out loud? ICR 29.1A. The prosecution's now completed their case, and I motion for dismissal or judgment of acquittal of any offense which the evidence is insufficient to sustain a conviction. The court, I don't believe that they've shown that I've been malicious or that I broke any laws there, and that my intent ever was to disturb the peace of a neighborhood, but a government official is what we were there addressing, and I think that's been shown out, even keeping the First Amendment out of it. I think that's been displayed within the evidence before the court at this time.
Thank you. Does the state wish to respond to the Rule 29 motion?
Thank you, Your Honor. So, as the court is aware, Rule 29 is viewed most favorably to the non-moving party. I do think that a rational or reasonable trier of fact, given all the evidence before them, can conclude that Robert Jones did show up at the neighborhood and proceed by way of banging, by way of horn, and by way of yelling to disturb that neighborhood. And in fact did do those things. I know Mr. Jones disputes in the video whether he does or not. The trier of fact does have that video. Just from my own recollection, there is a portion where you can see Mr. Jones with a canister. It's white with a blue tip. I think that I know that once again he disputes that, but I think the video speaks for itself. I guess given all of that, Your Honor, I'd ask that you deny the motion.
Okay. And Rule 29 states that after the prosecution closes its evidence or after the close of all the evidence, the court on defendant's motion or on its own motion must enter a judgment of acquittal of any offense for which the evidence is insufficient to sustain an objection or a conviction, excuse me. And if the court denies a motion for judgment of acquittal at the close of the prosecution's evidence, the defendant may offer evidence. If the court dismisses an offense, the court must consider whether the evidence would be sufficient to sustain a conviction on a lesser included offense. In this case, the elements of disturbing the peace include the date that it occurred in the state of Idaho, that the defendant maliciously and willfully disturbed the peace or quiet of a neighborhood, family, or person by loud or unusual noise. And I find that the motion should be denied and that the state has produced some evidence that a jury could find that the elements have been met. And so in the combination of testimony and video. And so I will go ahead and deny the motion, sir, and then you may now decide, did you wish to put on your own case?
Yes, ma'am.